by them. 67% of these women indicated the homicide resulted from an attempt to protect themselves or their children. During the informational hearing, I was also informed about the difficulties in finding these women representation and about the domestic violence victims that were unintentionally denied their original writ of habeas corpus due to limited expert testimony evidence. In 2002, the legislature passed AB 799, which provided relief for all domestic violence victims who lacked expert testimony during their original trial proceedings. However, there are women who have been battered, women who have been denied access to relief. AB 593 achieves the original intent of AB 799 by allowing victims of domestic violence whose expert testimony was limited at their trial court proceedings to refile for writ of habeas corpus. Due to the amount of time needed to investigate these 20-plus year cases, only 16 women have successfully petitioned for a writ and have been released by the courts. According to the Habeas Project, which helps find legal representation for women that qualify for the writ, there are 19 women still waiting for attorneys, some of whom have been waiting for over 5 years. By the time legal representation is found, investigations are conducted and habeas petitions are prepared, and the sunset clause originally in PC 1473.5 may preclude these women from seeking relief. AB 593 also gives victims more time to receive legal representation by deleting the sunset date currently in the statute. I continue to work with the Judicial Council to address their concerns, and with me here is Marissa with the California Habeas Project, who could talk about how difficult it is for lawyers, for victims or incarcerated women to find lawyers, on how long it takes for these cases. Also with me is Brenda. She is the star of Sin by Silence, who can talk a little bit about her own case and how long she served in prison, and also the California Partnership to End Domestic Violence.
Thank you very much. And usually what we do is limit witnesses to 2 minutes each, and sometimes we get flexible if required, but so please.
Good morning. My name is Marissa Gonzalez, and I'm a staff attorney at Legal Services for Prisoners with Children, where I'm the coordinator of the California Habeas Project. The Habeas Project is a collaboration of 4 organizations across the state that work to implement Penal Code Section 1473.5, the law that AB 593 amends. I'm here today to urge you to vote yes on AB 593. This bill will help secure due process and advance justice by giving more incarcerated domestic violence victims access to habeas corpus relief, as well as the time necessary to show how they were prejudiced in court by the lack of expert testimony on domestic violence when their cases originally were prosecuted. This bill does not guarantee the release of anyone convicted of a violent crime. It simply gives eligible victims who seek relief an opportunity to be heard. At the time when the women I work with were convicted, expert testimony on domestic violence was really in its infancy. Many judges did not understand the relevance of this kind of testimony or the extent to which experts were allowed to testify. As a result, some judges limited the testimony of experts in ways that prejudiced battered women defendants. For example, some judges allowed experts to testify about domestic violence generally, but refused to allow the experts to testify about the specific effects of abuse on the woman being prosecuted. This confused juries and prejudiced battered women defendants. AB 593 finally would allow these battered women access to habeas corpus relief. Additionally, AB 593 would remove the sunset clause that's currently in place in Penal Code Section 1473.5. There are no state funds appropriated to implement 1473.5, so people can file petitions on their own, but it's difficult for unrepresented prisoners to be successful in court. Instead, it falls on nonprofit organizations like mine, along with USC's law school and the LA County Public Defender's Office, to recruit, train, and support volunteer legal teams.
I'm going to have to ask you to wrap up. There'll be questions.
So because of those limited resources, it's taking a long time for these cases, and the sunset clause being removed would mean that people would have access to justice rather than being arbitrarily denied that access.
Thank you very much. Next witness in support.
Hello, I'm Brenda Klubine. I'm here today to urge you to vote yes on AB 593. This new legislation would be a huge step towards making a difference to help incarcerated domestic violence survivors. You see, I remember the first time my husband beat me. It was horrible. I was thrown across the room like I was a rag doll, and he didn't care. I remember the moment, though, that I had to make the horrible decision to defend my life against him, which resulted in his death. When I went to trial, I was only 20 years old and scared to death. I couldn't figure out, how did I get there? Did anybody want to listen, or did anybody really care about what I'd been through? I never meant to take my husband's life. I had piles of evidence, I had photographs, I had reports, and I had paperwork from the police department. Yet none of it was allowed to be presented in my trial. My judge said, "Ms. Klubine, your case will not be the case to set a precedent for the state of California." So I received a sentence of second-degree murder with 16 years to life, and I remember thinking how the laws were not in place to help me then. On October 21st of 2008, however, I finally received my freedom after 26 years behind bars. I was finally able to present the evidence that should have been permitted in my original trial because of 1473.5. I was finally able to experience the freedom I had only dreamed of for years. I was finally able to hug my son and get to know my grandkids. And I'm here today to help my sisters, who unfortunately I had to leave behind. I'm here to be the face you remember relating to the injustice of keeping incarcerated, battered women behind bars. These are my sisters. I'm here to be the voice that represents the women who are lost in the system still today. I'm here today representing injustice of trials that did not permit what today's courts embrace. I represent 26 years in prison because the laws were not in place so that I would have a fair trial. I'm here today to ask your help and to say yes to AB 593. It's not fair that I get to experience freedom while my sisters are left behind, and they deserve the chance that I received by expanding the laws for those few more who deserve the chance to be fairly heard in court. AB 593 gives them a chance to be here sitting beside me and making a difference in this world. I was robbed of 26 years of my life that I could have had with my family. 26 years that I never would have had served if legislators such as yourselves today would have done the right thing to make sure the laws were in place to help me back then. So I'm asking for your help now. I'm asking you to help my sisters who are left behind now. I'm asking you to do the right thing, and please vote yes on 593.
Thank you very, very much. Any further witnesses in support?
Yes.
Just name and affiliation.
Yes, Tara Shabazz, Executive Director of the California Partnership to End Domestic Violence, and we are in support of this bill as well. Thank you.
Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice, also here in support of the bill.
Thank you. Any other witnesses in support? Any witnesses in opposition?
Good morning, Mr. Chair and members. Corey Salzillo on behalf of the California District Attorneys Association. We are not in opposition, and with the chair's indulgence, we've worked with the author and the proponents and the staff on this bill. We do have some concerns about the language, the vagueness of the word limited. There is some argument that evidence that could be brought in under this it could be brought in under a traditional claim of habeas and or an appeal that is afforded to every person who's convicted of an offense. So we would just urge the author and the proponents to continue working to refine the language so that there's absolute clarity as to what we're talking about. And I would just point out for the committee's knowledge that this current sunset doesn't expire until 2020, or 8 years from now. Thank you.
All right, thank you. Any other witnesses in opposition or neutral? All right, seeing none, any comments or questions from committee members? All right, we do have a quorum. So Mr. Hagman, let us establish the quorum if you don't mind, then we'll.
Armiano,
Here.
Knight, here. Cedillo, Hagman, here. Mitchell, here. Skinner, vacancy.
Okay. And do we want to do the consent calendar? Since we move it, second. And without objection.
Armiano,
Aye.
Amiano, aye. Knight. Knight, aye. Cedillo. Hagman. Hagman, aye. Mitchell. Mitchell, aye. Skinner. Vacancy. It's out.
All right, thank you. Mr. Hagman, thanks for your patience.
Thank you, Mr. Chair, and thank you, Ms. Mott. I mean, the subject matter, I think we all agree upon this needs to be in the rules and regs, and it is. There's 2 points that I have questions on, and I want to see if the author could address it. One is the definition of limited. And when you're dealing with the court structure, that's such a vague term that pretty much anything and everything can be thrown underneath there. And I was wondering what your intentions would do if this, make it out of committee to keep going. Are you going to try to redefine what that is, what limited may be in that scope? And then I guess the second question would be, assuming that part gets fixed, we're basically halfway through this sunset period. These are crimes that can be considered prior, 1979, I believe? 92, I'm sorry, 1992. So we're into it for 10 years. We got another 7 or 8 years left before the sunset goes. So we're basically removing the sunset. I can see 2 separate actions here. One, if you're getting tied up in court of having problems, and I've been working in courts for 20 years, I know how that's like. But you have to be more specific besides limited. That just opens it up and probably cause you more problems. Then the second part would be extending the time length, but we're 7, 8 years away from it, and I would like to see that part of it maybe go down when it gets closer to show if there's still need at that time. 8 years from now is a long time away. So I guess the main thing is the definition.
So I'm going to have Marissa talk about how long it takes for these cases, even to get an attorney to take on a case, and then how long it takes for the attorneys to prepare. And so we're still talking about 19 women still waiting for attorneys. So on average, it probably takes...
Some of these women have been waiting for over 6 years to get attorneys in the first place. So what we have found is with the economy changing the way that it has, getting pro bono assistance for women has really slowed down. In the last year, I was able to assign out 3 cases. So with 19 women at that rate, it's going to take another at least 6 years before every woman has an attorney. And then these cases are decades old, so having to do the investigation, try to track down witnesses, try to track down documentation from 20 plus years ago takes time. To put that together, to give that to an expert, there are very few experts on this subject matter in our state. So trying to work with an expert who's already working with maybe 5 other legal teams and get her time and attention, get that expert report in place to finally file the petition. We've found that petitions can take anywhere from 3 to 7 years from the time that the case is assigned out to the time that it's...
I agree. I know how long, especially redigging up an old case, could be, just like the appellate case or whatever. What I'm wondering, though, is that if you came 2 years out before the sunset date and says, look, I still have 25 ladies, we're still looking at 25-plus-year-old cases at that time. By a lot of times, unless it's a capital case, those things are going to be adjudicated out, and one way or the other, these ladies are going to be out. So you're going to be limited to the capital cases probably, or 3 strikers at that point, if we still have 3 strikes. And so 6 years from now, I can see that argument coming back. We still have a waiting list. We're still plowing through them. Not necessary today. So I think you're trying to do 2 things with one bill. One is extend it probably earlier than needed to be, because we haven't got to that stage 2 years. And the second thing is redefine what can be used or to reapply for this case. And so the first part is more important to me, too, as well, is the definition of limited. And, again, not that you're going to have all the answers today, what's the intentions as this moves on to try to address what that is.
Right. So in Brenda's case, it took 4.5 years for the attorney to prepare her case. And, if we had a lot of money, of course, we started with, we need to get attorneys for all these women. But, of course, we don't have money. So, the second thing is to try to help the Habeas Project encourage more attorneys to take on these projects, and knowing that the sunsets are not going to expire, I think gives a little more positive influence to these cases, to these women, to know that they're not going to put 4 years into their life, and then potentially in 2020 the case is going to expire, and then all the work goes down the drain. That's the one purpose. I am committed to this. I've been the chair of the Domestic Violence Select Committee for the 6 years. I'm doing what I can, given the parameters of our situation, fiscal situation at this time. But I think giving, the hope for the victims that their window is not going to close is a huge thing for them. Secondly, I am working with the Judicial Council on the definition of limited. I know it is very technical, and there are a lot of questions, and I appreciate Corey and the DAs working with us on this, and we'll continue to work with the committee.
We really respect your commitment to, because there are some technical questions, and we want to make sure, because there's so many interpretations sometimes in gray areas, that, because I'm very supportive of this bill, and I don't want anything to come back and revisit us if that's the case. But,
right.
Okay. Any other comments, Ms. Mitchell?
Thank you very much, Ms. Ma, for your work in this area and for bringing this bill forward today, at least to give me an opportunity to support it and vote aye. I appreciate the concern with regard to timing of the bill in terms of eliminating the sunset. I think, speaking politically, I think now is the time that we certainly have the climate where we know it will be supported today, and I don't know that will be the case in 6 to 8 years. And so I applaud you for bringing it forward today, and I'll be supporting you wholeheartedly.
Thank you very much. Would you like to close?
No, I think my witnesses have explained the situation, but maybe Brenda would like to say a couple words.
Briefly.
I just want to say in closing that, you know what, I thank you all for your courage and everyone that's going to be a part of making this difference, because it matters. It really does. You have no idea how important this is.
Thank you so much. All right. If we could take a meeting motion. Move the bill, a second. All right. And the chair has recommended an aye vote.
Amiano?
Aye.
Amiano, aye. Knight? Knight, no. Cedillo? Hagman? Hagman not voting. Mitchell? Aye. Mitchell, aye. Skinner? Aye. Skinner, aye. Vacancy. It's on call. It needs one.
Okay, it needs one more vote. We're going to have additional members coming in.
Thank you. Thank you, members.
All right, I have Mr. Dickinson next, but I don't see him. But it's Mr. Donnelly. Looks like you're up. AB 1031. Item number 6. Okay, sir.
Good morning, Mr. Chair, members. I bring you AB 1031. This is a simple bill. The goal is to bring California into compliance with federal law in the area of drunk driving. Right now, in California, existing law requires an arresting agency to notify the appropriate federal agency if the arresting agency has reason to believe that a person arrested for the possession, transportation, sale, or giving away of a controlled substance, a specified controlled substance, may not be a citizen of the United States. But it does not require that if they're simply drunk driving. So I'm asking that we bring California in compliance, and that this bill would require the requesting, excuse me.
Sorry, sir. Go ahead.
This bill would require an arresting authority to report to the United States Immigration Customs Enforcement the presence of a person if the person arrested for driving while under the influence of an alcoholic beverage or drug, or the combined influence thereof, alcoholic beverage or drug, and the person fails to provide the arresting officer with the appropriate documentation demonstrating his or her legal presence in the United States. You know, all of us know someone who's been killed, or someone whose life has been affected by those who drive drunk. That moment is compounded, and that pain and tragedy is compounded when that death is preventable. And for me, this is personal. This is not just about pushing a bill or trying to change legislation. In 2006, I was driving home from a trip, and I found out that a very good friend of mine had his wife had her legs crushed by someone who drove down her street while she was putting her kids in the car and crushed her up against her vehicle. That individual backed up. The car had conked out. He had come at such a high rate of speed. The husband watched in horror as his wife's body crumpled into the street. He ran out there and picked her up and said, "Lillian, Lillian." And as he picked her up, he thought she was dead. And he's wondering about his kids and if they're okay. And he looks up and he sees the guy who ran into her and crushed her body and almost killed her. And that individual just backed up his car and took off. Fortunately, he was tracked down and tackled by some citizens in the neighborhood. The problem is, this happens more than once. That individual's name was John Clark. Bob Clark, who wrote the Christmas Story, the movie we watch every Christmas, was killed by somebody illegally in the country on a dark December night. This is a preventable cause of death, and I urge you to give me an aye vote on protecting our communities from something. It's one thing for people to come into our country and want to have a better life. All of us have some empathy for that. It's another thing to come here, choose to drive drunk, and take the life of a citizen or severely injure them and change their life and create a tragedy for their families. I ask you for an aye vote.
All right, sir, thank you. Do you have any witnesses in support?
I do not.
Are there any witnesses in opposition?
Tiffany Mock on behalf of the American Civil Liberties Union. We oppose this bill because we believe that there are constitutional and public safety rules that mandate that we oppose this. Like Mr. Donnelly, we believe that drunk driving is a serious problem and we do not want it in any way. And for those, in part for those reasons, we oppose this. We believe that public safety is benefited when federal government does its job, which is immigration enforcement, and local resources are spent on crimes such as that are local. Immigration is in the jurisdiction of the federal government, as the courts at all levels have said numerous times. And for those reasons, we oppose.
All right, thank you. Next speaker.
Jim Lindberg on behalf of the Friends Committee on Legislation of California. We think there are very good reasons for keeping the enforcement of federal immigration law separate from local government agencies. Immigration law is complex. It should be enforced only by those federal agencies who are trained to exercise their authority with due regard for the rights of undocumented residents. We think there's a serious unintended consequence if the line between immigration law and local law becomes blurred. We're concerned that undocumented residents are less likely to report crimes as a result, and to the detriment of public safety for all of us. Thank you.
Thank you. Next speaker, please.
Margaret Laffin, on behalf of Legal Services for Prisoners with Children. We oppose this bill for all of the reasons already mentioned.
Ignacio Hernandez on behalf of the California Immigrant Policy Center, the California Attorneys for Criminal Justice, and the California DUI Lawyers Association. All three organizations are opposed to the bill for the reasons stated. Let me just add one more. We've been doing some work in Arizona, and the Department of Justice just came out with a very scathing report about the types of racial profiling that often goes along with these types of local law enforcement attempts to enforce federal immigration law. This is just going to really open the door to significant more racial profiling. The statistics and the analysis really capture the disproportionate number of Latinos that are arrested and suspected of DUI offenses, and I think we need to take steps to address the current threats to racial profiling before we do anything like this. I ask for your opposition.
All right, thank you very much. Are there any other witnesses in opposition? Seeing none, committee members. Mr. Hagman.
Thank you, Mr. Chair. And for the witnesses that just testified against, are you suggesting that local law enforcement should not enforce any federal laws on the books? That's kind of part where your argument was, keeping federal law different from local law? I thought law enforcement is supposed to enforce law enforcement, and in this particular bill, it's just a referral to the federal immigration, is it not? They're not actually determining what the outcome is. I don't get that argument. If you could elaborate.
Okay. Response, please.
Yes, the ACLU believes in immigration matters, that the federal government should be in charge of deportations and immigration enforcement, and that local law enforcement should enforce local and state crimes.
Yeah, Mr. Chair, thank you for the question, Assembly Member. Let me just one note on that. Immigration offenses are civil offenses; they're not criminal offenses, and there is, as we all know, layers of legal debate as to what the role is for local government in terms of enforcing federal civil immigration laws. So to your question, I think we could probably have another discussion about other federal laws that can be enforced. We can talk about federal marijuana laws. We can talk about lots of other things. But in terms of immigration, there's huge debate, and I think it's very instructive what occurred in Arizona just the last few weeks about really focusing on the debate of what local government should be able to do in terms of immigration. I think this bill goes far beyond what's allowed and also opens up to other problems. Law enforcement does make mistakes occasionally, and this is really going to open the door to mistakes that are going to target one particular group.
Thank you. Mr. Knight?
I think that this whole argument is just flawed, because outside of a sanctuary city, which we know we have many here in California, and I guess we can debate Arizona law all we want, but the fact is this is California. Outside of a sanctuary city, police officers do identify, and they do notify. That is part of what law enforcement does. This bill is just saying that if that is a DUI driver, that there will be a notification. I don't know that we're taking it any further than that. I think that there's also always a cop-out to say that police officers will target people of color if we do something up here. It'll always be, they will target somebody of color if we do this. That's always the cop-out that I hear up here. Let's remember that racial profiling has been described as illegal, that police officers cannot engage in that. They can engage in criminal profiling. So as we move along this process, all we are talking about is something that is already happening outside of sanctuary cities. We're just saying that if they are involved in this criminal activity, we should be able to identify and push forward to ICE.
Okay. Any other comments? Ms. Skinner?
Well, actually, law enforcement has this right. We don't need to mandate it. There's no need for the bill. They have this right at present.
Okay. Any other comments? Ms. Mitchell, sorry.
Thank you, Mr. Chair. Mr. Donnelly, the tragic story you shared about your friend was compelling and indeed tragic, and I'm sorry to hear that. I guess my issue with the bill is nothing in the bill helps prevent DUIs.
Well, actually,
unless you're assuming that by a referral to ICE would remove the undocumented individual from the country and reduce the likelihood of future DUIs. But when I look in the analysis and under the author's comments, I think the statistics you share with regard to the number of DUIs that occur in our state on an annual basis, are you inferring that that the vast majority of them are done by individuals who are undocumented?
No, I've made no such inference. But what I would say is very simply, the individual who hit my friend had been arrested 3 times and never deported for DUI.
Mm-hmm. And then, as Ms. Skinner just referenced, law enforcement currently is empowered to make referrals to ICE.
And had
under any arrest, I'm assuming, DUI or any other encounter with an individual that they suspect is undocumented.
If there was no need for this law, I would not be here. If this were common practice, if we didn't have the sanctuary cities that have created loopholes, then we wouldn't have communities at risk. My friend lived in had the unfortunate circumstance of living in an area where the authorities just look the other way. What I think we need to do is create a secure community so that the law is uniformly enforced across the state of California. And you understand that if you choose to engage in the behavior, this has nothing to do with color or anything else, it has to do with choosing to drive drunk, then there will be a consequence, which is you will be referred to ICE. Now, that doesn't mean you're going to be automatically deported. You'll have to go fight a case. But at least the citizens of that community will no longer have to deal with you driving drunk down their street. That is my goal.
Thank you. Ms. Mitchell, did you have anything for Mr. Hernandez?
No, but it looks like he has something for us.
Well, thank you for inquiring, Assembly Member. Just very quickly, and I think the analysis points it out, the misdemeanor DUI offense, which is essentially a first offense, is not a deportable offense, and that's determined by the federal government. So that's really what we're talking about. I think the situation that was raised by the author, the multiple DUI offenses and injuries, was probably a felony and likely deportable. So.
Thank you. Mr. Donnelly, would you like to close?
Yes. In almost every case where someone is killed by someone who is driven drunk and who turns out to be in the country illegally, there have been multiple ignoring of the fact that they had driven drunk before. There has always been multiple offenses.
That's a factual statement?
I'm saying in most cases that I'm aware of.
That you're aware of.
And so that is why I brought this bill forward, because I think it is critically important that we prevent unnecessary deaths in our community and that we hold people accountable. I ask and urge and I vote.
Thank you, sir. And while I do agree with the need to have consequences for behavior, and very, very unhappy with your personal experience, I imagine it's a loss that will always have to be dealt with. I just feel that the focus on the undocumented presents many, many problems for me, particularly around constitutionality. I would like to work on solutions, and the committee has in the past, on DUI laws that serve the purpose that you're talking about. But I'm going to recommend a no vote and urge my colleagues to oppose also. Right, Madam Clerk?
I need a motion.
Bill's been moved.
Amiano?
There's no second? Oh, you seconded. Thank you. Yeah.
Amiano?
No.
Amiano, no. Knight? Knight, aye. Cedillo? Hagman? Cedillo, no. Hagman, aye. Mitchell? No. Mitchell, no. Skinner? No. Skinner, no. Vacancy. The bill is
Okay, the bill has failed passage 2-4. Thank you, Mr. Donnelly.
Thank you.
And Mr. Dickinson.
Good morning, Mr. Chairman and members. This is AB 526, which I'm pleased to present as a measure that will improve the effectiveness and efficiency in the granting of state and federal funds for delinquency and gang intervention and prevention programs. The bill amends current law to require three things of the new Board of State and Community Corrections, which has assumed the duties of the now defunct Office of Gang and Youth Violence Policy. Specifically, the bill would do the following. It would identify opportunities to consolidate. I should say the bill would require the board to do the following, just to be clear. It would require the board to identify opportunities to consolidate and unify grant applications when the board finds that multiple gang intervention prevention funding streams are serving similar populations, have similar purposes, or intended to achieve similar outcomes. Secondly, it would require the board to develop incentives which will encourage regional partnerships in the use of gang intervention and prevention grant funds. And third, it would focus 85% of the gang prevention and intervention funding on programs which operate according to evidence-based practices and principles. As some of the members of the committee may know, I chair both the Accountability and Administrative Review Committee and the Select Committee on Delinquency Prevention and Youth Development. Through hearings that we have held with those two committees over the past 3 years, we have found a number of things that I think are of concern and deserve attention leading to this legislation. And I'd just like to mention a couple of those. First, there's little, if any, coordination or collaboration among the nearly 20 state departments and agencies that administer funding streams that total more than $1.5 billion in state and federal funds intended in one way or another to prevent delinquency and foster youth development, which are allocated to local agencies. Secondly, despite these expenditures, the state has little ability to determine which programs have been the most effective at preventing youth crime and lowering recidivism rate among juvenile defenders. Third, there is little in the way of information sharing among the departments and agencies that administer this $1.5 billion worth of grant funding. And despite, fourth, the increasing body of knowledge demonstrating evidence-based programming is the most effective in achieving the goal of reducing gang violence and spurring youth development, few state agencies require delinquency and gang intervention and prevention funding to be allocated to such programs. Finally, as a note, there's no state strategic plan for investments in youth development and delinquency measures, and as a consequence, we have duplication and inefficiency oftentimes in the grant-making process. We know that this board now has been tasked by the legislature and the governor with taking a leadership role. It's enunciated in the budget, and so the changes encompassed in AB 526 will begin to address some of these facts that I've enumerated and hopefully set the stage for a more comprehensive structuring of state delinquency prevention and youth development work. Mr. Chairman, thank you for your indulgence, and I would respectfully ask for an aye vote.
Thank you very much, sir. Is there a witness or witnesses in support? We usually limit to 2 minutes.
Mr. Chairman, members, Dan Filizato on behalf of the Los Angeles County District Attorney's Office. Unfortunately, we didn't get a position in time for the committee. However, LA being the gang capital of the world and having a huge delinquency problem, our office recognizes that the limited money that's available due to our fiscal condition needs to be spent wiser and better, and believe that focusing on evidence-based programs that have based on evidence-based practices is a good idea. Okay. And so we respectfully request the committee pass this bill.
Thank you very much. Further witnesses in support?
Good morning. My name is Shonda Johnson. I'm representing Sacramento Act and PICO in support of AB 526.
Thank you so much. Any other witnesses in support? Any witnesses in opposition? All right. Seeing none, any questions or comments from committee members? All right. I would like a motion if you want to close.
I only want to note that Mr. Hagman, I want to thank him. He attended one of our select committee hearings in Los Angeles, which I think we found to be very useful. Other than that, I would just repeat, I'd ask for an aye vote. Thank you, Mr. Chairman.
Okay, you get extra credit, Mr. Hagman, A+. Oh, and we need a second as well. Second. I know you've been doing a lot of work on juvenile justice, and I really appreciate it. And I think streamlining this is a great idea. You know, there's enough obstacles as there is. So I am recommending an aye vote.
Amiano?
Aye.
Amiano, aye. Knight?
Aye.
Knight, aye. Cedillo? Cedillo, aye. Hagman? Hagman, aye. Mitchell? Aye. Mitchell, aye. Skinner? Aye. Skinner, aye. Vacancy. The bill's out.
Okay, your bill is out.
Thank you, Mr. Chairman.
Let's see, Ms. Mitchell, would you like to present for Mr. Davis? Item number one.
Thank you, Mr. Chair and members. Our colleague, Mr. Davis, is still out of the state, so I'm happy to present on his behalf today AB 327. This is a measure that we would put on the ballot to require that the third strike in California's three strikes law be required to be a serious or violent felony in the same way that the first two strikes are currently required under current law. Again, currently, any third felony, if it's followed by two serious or violent felonies, automatically constitutes a third strike, which calls for the automatic sentence of 25 years to life in prison. Current three strikes law has led to many sentences over the past 18 years that were not proportionate to the offense. Furthermore, it poses a threat to the economic health of our state. Over 40% of the third strikers in state prison are there for non-serious or non-violent offenses who, due to the current policy, are serving 25 to life sentences while the taxpayers foot the bill. Mr. Davis is continuing discussions with interested parties, including the LADA's office, in regards to a more just method of sentencing nonviolent and non-serious offenders. Here with me in support of the bill are Michael Reynolds with the California NAACP, Jim Lindberg with Friends Committee on Legislation of California, and Ignacio Hernandez with the California Attorneys for Criminal Justice.
Okay. First witness, please, in support.
Good morning, Mr. Chair, members of the committee. My name is Mike Reynolds. I am the legislative advocate with the California State Conference of the NAACP. I'm here on behalf of our president, Ms. Alice Huffman, and our 52 branches and over 30 youth and college divisions to express our support for AB 327. This bill would provide a defendant who has two or more prior violent or serious felony convictions shall receive the mandatory 25 years to life sentence only if defendant's current conviction is for a serious or violent felony. The NAACP believes that this bill is needed to not only help put an end to unjust and inequitable sentencing for nonviolent third strike offenders, but to also ensure the fiscal health of our great state. As a result of mandatory sentencing laws under which we currently live, young African-American men and women are being sent to prison in unnecessarily disproportionate and unacceptably high rates for far too long. As a result of these laws, which is especially problematic for organizations who are engaged in civil rights and criminal justice matters like the NAACP, is that ethnic minority Americans, especially African Americans and Latinos, are disproportionately sentenced to lengthy prison terms. Nearly 2/3 of the people sentenced under California's three strikes law are convicted of nonviolent offenses. African Americans struck out at 12 times the rate of their Caucasian counterparts, and Latino incarceration rate for a third strike is 45% higher than that of whites. Mandatory minimum sentences have not reduced sentencing discrepancies. Rather, they have transferred discretion from judges who are put through a rigorous confirmation process that focuses on their ability to be fair and balanced to prosecutors who are hired to seek criminal convictions for the city, state, or nation. California's three-strike law is one of the harshest sentencing laws in the country that results in excessive costs on our budget. The law has cost the state an additional $8.1 billion over the last 10 years and has had an untold impact on the lives and communities that are ruined when a nonviolent offender is given a sentence of 25 years to life. This is $8.1 billion that could have rather been spent on education, job creation, health care, interdiction, and alternatives to incarceration programs. The NAACP believes that had this money been spent on something other than locking up nonviolent offenders, that the state would have seen a more significant drop in crime than the authors and the intent of the law had hoped for. In closing, mandatory minimum sentences do not work as intended. Rather, they work to further destroy communities and exacerbate the racial divide that alienates so many young people of color today. The NAACP remains very opposed to mandatory minimum sentences, and that is why we support this measure to amend the current three strikes law in California in a way that will ensure fairness and equity in the enforcement of the law, and also to take the burden off of the taxpayer to foot the bill for long-term incarceration and nonviolent offenders.
Thank you very much. And I gave the speaker a little more time so he could finish his statement, so I appreciate an accommodation.
Thank you. Jim Lindberg on behalf of the Friends Committee on Legislation of California, a Quaker-based statewide advocacy group. We do oppose the current California three strikes law. We think it results in grossly disproportionate sentences for nonviolent, non-serious offenses. We disagree with those who claim that three strikes has been an effective crime fighter. We would point to other states such as New York, who does not have a three strikes law and has experienced a greater reduction in crime rates. We think that the voters ought to have another look at this, and we're in strong support of the bill. We are concerned about the second and third strikers who are currently serving sentences who are not impacted by this bill, but nevertheless we think this bill is an important step in the right direction and is deserving of support. Thank you.
Thank you.
Good morning, Glenn Backus, representing the Drug Policy Alliance and representing the Ella Baker Center for Human Rights, both in support. Thank you.
Thank you. Any other witnesses in support? Any witnesses in opposition?
Mr. Chair and members, Corey Salzillo on behalf of the California District Attorneys Association.
Thank you. And I did give the gentleman a little more time, so we'll make it equitable if you need to.
Thank you, sir. Thank you, ma'am. Just let me first say that the California District Attorneys Association is very much opposed to this measure. We feel that the district attorneys have used their discretion appropriately in the enforcement of this law. And let me just back up and say that 3 strikes is not automatic, as the proponents have said. The law requires the charging of strikes. However, the law very much allows a district attorney to request on his or her own motion that a strike be dismissed, either in the interest of justice or because he or she doesn't think they can prove the strike. In a 1996 Cal Supreme Court case, People v. Romero, or People v. Superior Court, which is referred to as Romero, the court made it very clear that a court can, on its own motion, strike a strike. So this notion that anybody who is charged and convicted of a 3rd felony after 2 serious and or violent felonies automatically gets 25 to life is just flat wrong. So let's not have any illusions about that. There is discretion at the DA level and the judicial level, as I mentioned. A 3rd strike trial where a person is subjected to a life term receives 20 peremptory juror challenges on both sides as opposed to 10 in a typical felony jury trial, which gives even more assurance that there will be a fair jury trial. And when a person is convicted, there are multiple levels of appeal. You can appeal at the state level. They can ask a question on whether or not the court should have dismissed a strike, whether or not they should have reduced a crime that's a wobbler to a misdemeanor. Is the penalty cruel and unusual punishment? And if that's all unsuccessful, they can file a habeas corpus petition at the state. And when that's unsuccessful, they can file the same challenges at the federal level. As of September 30th, 2011, there were 8,813 third strikers in California's prisons. Out of the total 135,000 that are in adult facilities today, that accounts to 6.5% of our prison population. So the notion that 3 strikes is clogging California's prisons is also flat wrong. And we must remember when we look at the ballot initiative that approved 3 strikes, Prop 184 from 1994, this was not about violent offenders. It was about repeat offenders. And so we have to be clear about what we're talking about. We're talking about a tool for prosecutors to get recidivist criminals off of our streets. And with that, I would ask for your no vote.
Thank you very much. Next witness, please.
Thank you. Good morning, Mr. Chair and members. Dawn Kepke with McHugh, Kepke and Associates on behalf of Crime Victims United of California, also in strong opposition. Echoing the comments made by the DA representative, also just noting that many crimes, as CVUC has noted over the years, are labeled nonviolent, non-serious, but are indeed serious, if not violent offenses. Everything from human trafficking, solicitation for murder, and many others are not classified by the Penal Code as serious and violent offenses. And so we are highly concerned these offenders essentially would be eligible for being back out on the street. This is something that is taken into consideration per the DA's comment about recidivism, about showing increasing level of criminality and what have you. And so that, as well as the comments made by the DA's Association, we strongly oppose. Thank you.
All right. Thank you, ma'am.
Mr. Chairman, members, Dan Filizzato on behalf of the Los Angeles County District Attorney's Office. As Ms. Mitchell stated on behalf of Mr. Davis, our office has been in conversations with them. As currently drafted, the Los Angeles District Attorney's Office would strongly oppose AB 327 because it takes away the discretion that our office has. Mr. Cooley, our district attorney, previously sponsored legislation carried by Senator Romero. We've been in discussions with Mr. Davis's office to see if the author would be inclined to amend his bill to reflect more closely the Romero legislation from 2006. So with that, I respectfully ask the committee.
Okay, thank you very much. Any other witnesses in opposition? Seeing none, Mr. Hagman.
Thank you, Mr. Chair. And the opposition witness covered a lot of my points, but just some of the facts. I mean, the facts are that this is not rampant out there. When we first started the program back in 1994, 2001, there was almost 7,000 arrests. In the last, 10 years, it's been in the 100, 110, 115, 125. So it does desire the fact that voters voted in the fact that they wanted to get repeat offenders off the streets. And we can't, we do the cost analysis. We built 19 prisons before 3 strikes. We built 1 since. Our prison population has stayed steady, and our population has increased 6.1 million. We have had that desired effect. And I think with the tools that, every time major legislation comes out, we're going through that right now, realignment. There's always fixing after to get that intended consequences. That was addressed with Romero. It was addressed with putting discretion in the district attorneys and the courts to be able to look at these cases and say that really doesn't rise to what the voters had. And that power has been successfully placed in the courts. And it should stay there, not back with the legislation by redefining this. I would urge a no vote as well.
Thank you, Mr. Hagman. Any other comments or questions from the panel? Mr. Knight.
I'll make a quick comment. A couple things that were said. It is about repeat offenders. I know that police work always talks about the 10% of criminals that do about 90% of the crime, and those are the people that have repeat offenses. They've got a rap sheet that has potential strikes on there, and you could see a rap sheet that's 40 pages long and might have 10 or 12 potential strikes on there. Those are the individuals that have demonstrated that they don't want to follow the laws, that they are outside of the bounds, and that the people of Prop 184 said that these are the ones that should be locked up. Now, the people that do have a mistake, or they get arrested and they can get rehabilitated and get back into society, those are the ones we absolutely want to help. There's absolutely should be rehabilitation for everyone who wants to, but some don't want it. And I think that's what Prop 184 said, was that repeat offenders, the people that just continually do this, that third strike does not have to be violent because they have already shown that they can be violent. I think the 6% total is very important. I think that everyone thinks that this is rampant and that 85% of our prisons are third strikers, and that's just not the truth. I have a bit of information from the Department of Corrections that shows our total violent crime arrests. From 1994, we had a little over 318,000. In 2007, we had 191,000. Now, it has continually gone down, continually. That would say to me that if we do have the people that continually offend behind bars, they're not doing these violent crimes. They're not doing these crimes. So I think that there's plenty of information to show that 3 strikes has been very successful. I think the people have been behind it. They voted it in, almost 72%. I know that there's continual opposition to 3 strikes, and people want to change this, and I understand that. And I wish we had Mr. Davis here. I understand that Ms. Mitchell is a good author, and she supports this, but I always like when the author is here that we can ask him direct questions. But 3 strikes has been successful. We've seen that. So changing it, I think, would be hurting what the people of Prop 184 wanted.
Thank you very much. Any other comments or questions? Ms. Mitchell, would you like to close?
Thank you very much. Mr. Knight, I don't know if you're aware that Mr. Davis lost his father recently, so I'm sure absent that he would be more than happy to be here to defend the bill that he's introduced and put a lot of time and energy into carrying. I think that we shouldn't fool ourselves in terms of the cost of, I appreciate that it's 6%, but 60% multiplied by 25 years is a significant amount of money, and so we shouldn't dismiss that, particularly given the bankrupt climate in which we all are attempting to legislate. So let's be really clear that those kinds of dollars reinvested in the Department of Corrections and Rehabilitation in more productive areas in terms of efforts to reduce repeat offenders would really be, I think, a productive use of very limited resources. I would hope that in the future, it was an interesting point to hear that the DAs do indeed have the authority to dismiss a strike. And I would hope in future testimony you would give us a sense of the frequency with which the DAs utilize that power and authority to kind of give a counterbalance to, I think, the information that was presented in Mr. Davis's fact sheet. I appreciate the fact that they have that power. How often is it typically utilized? That would be an interesting, I think, fact for me to have as a member of this body going forward supporting this bill. With that, I think Mr. Davis's perspective, the perspective of the NAACP and other organizations that represent the interest of people who are serving their third strike, who are serving currently 25 years in prison. And with that, I would ask for your aye vote.
Thank you very much. And do we have a motion? So moved. And a second. There's a motion and a second. Thank you very much to Mr. Davis, and our condolences to his family. I know he was very close to his father. And to you, Ms. Mitchell, thank you. And the panel, I myself feel that this bill is long overdue. If longer sentences made us safer, California would be one of the safest places on the planet. So I'm happy to support this bill, and I strongly encourage my colleagues to fix 3 strikes. So with that, we have a roll call, please.
Amiano?
Aye.
Amiano, aye. Knight? No. Knight, no. Cedillo? Cedillo, aye. Hagman? Hagman, no. Mitchell? Aye. Mitchell, aye. Skinner? Aye. Skinner, aye. Vacancy. The bill's out.
All right, the bill is out. Mr. Hagman has asked if we could just skip ahead for one moment and do our 2 vote-only items. And so if we could do that, please. Item 10. All right. And is there a second? Okay. And this is item 10. And this is Mr. Gurrell's bill, and the chair's recommendation is a no.
Amiano?
No.
Amiano, no. Knight? Knight, aye. Cedillo? Cedillo not voting. Hagman? Hagman, aye. Mitchell?
No.
Mitchell, no. Skinner? No. Skinner, no.
All right.
It fails.
The bill fails.
2 to 3, and I'll be.
2 to 3. Okay.
Could you announce it?
And then if we, I'm sorry, could we have a second on that?
We have a second.
Oh, we do. Okay. All right.
Can I speak on it?
You can explain the amendments. You could explain the amendments, yeah. Okay.
Could you announce that 281 failed and it'll be returned to the chief clerk?
Okay. I just want to announce that 281 failed and will be returned to the clerk. And Ms. Mitchell, you have another bill, don't you?
I do. Are you going to?
Yeah, he's going to explain his amendments, then we'll take the vote, and then you can.
Okay.
Go ahead, Mr. Knight, I'm sorry. And then that's it, right? We can just explain them.
Thank you, Mr. Chair. Thank you for allowing me to bring this back in reconsideration. AB 829 is simply to conform state with existing federal law, which recognizes the importance of retired peace officers to public safety. The recent amendments remove Level 2 reserve officers from the language and ensure the retirement policies of affected agencies is respected. Law enforcement organizations throughout the state support this common sense measure, and Jim Lombardi with the Reserve Police Officers Association is here today to answer any questions. I have just one further thing to say, that reserve officers typically will do police work inside their community, where a lot of police officers will not. They will drive 20, 30 miles to go to work. Reserve officers do it inside their backyard. And to say that a police officer who does this work for 25 years has this ability, but a reserve officer who does it in their backyard for 25 years does not have this ability is just wrong.
Thank you very much, and that is all our rules allow, and the motion has been moved and seconded, and I really do want to thank Mr. Knight for his accommodation. I still do have reservations about this and proliferation of guns, even in the hands of alleged professionals, and I'm not going to be supportive, but I did recommend a none recommendation because of my concerns, and if we could have a vote, please. Roll call.
Amiano? Amiano not voting. Knight?
Aye.
Knight, aye. Cedillo? Cedillo, aye. Hagman? Hagman, aye. Mitchell? Mitchell not voting. Skinner? Skinner not voting.
It's failed passage, and we'll go back to the clerk. Thank you, Mr. Knight. And Ms. Mitchell, if you wanted to pick up. And this is item number 9, AB 1432.
Thank you, Mr. Chair and members. I'm pleased today to present a bipartisan bill, AB 1432, which is in response to the recent highly publicized tragic death of a 2-year-old. Current law protects children from abuse and neglect. However, our laws do not compel a parent or guardian to report a child's death or disappearance. In this case, the mother chose not to report her toddler missing for 31 days. AB 1432 will create a 2-tiered misdemeanor violation for any parent or guardian who does not report the disappearance of a child aged 14 years or younger to law enforcement within 24 hours. Experienced law enforcement agrees that the first 48 hours of a child's disappearance are critical in determining if that child will and can be found alive. AB 1432 will give law enforcement the tools necessary to ensure the safety and well-being of our children. Assemblymember Morrell, who is a principal co-author, will make comments also about why he's supporting AB 1432.
Thank you. I thank you very much to Ms. Mitchell for having me be part of this. I'm very cautious on I love limited government, and I don't really agree when government infringes on parental rights. But unfortunately, sometimes there's some parents that are perhaps not worthy of having children. Sometimes I hate to say that, but it just really egregious when Kaylee Anthony went missing for 31 days, and her mother didn't report her. And so, one thing is we want to protect our most vulnerable, and of course that's our children. And so I wholeheartedly support Ms. Mitchell's bill, because we have to protect our children, as well as we have to give our highest priorities so law enforcement can protect our children. So we've answered the call from our constituents with AB 1432, and we'll make it a legal priority to enable our law enforcement to bring justice to those who would cause harm to our families and our most vulnerable. So thank you very much.
Thank you.
Good morning. Dawn Kepke, again, on behalf of Crime Victims United of California, as well as the Child Abuse Prevention Center, both in strong support of AB 1432. Both clients feel it's reprehensible for any parent to knowingly fail to report a disappearance or death of a child. And for that reason, we are supportive of this. And as Ms. Mitchell mentioned and was included in the analysis, the first 48 hours are critical to finding and or prosecuting crimes against children. And so the reporting of this in the most timely fashion possible is incredibly important. For those reasons we support. Thank you.
Thank you.
Mr. Chairman, members, Dan Filizzato on behalf of the Los Angeles County District Attorney's Office, and also today on behalf of Sheriff Lee Baca. Our offices have been working with Mitchell's staff. We are working on making some small changes to the language, but think that this is an excellent idea, and respectfully request that the committee pass this bill along to its next hearing.
All right, thank you. Are there any other witnesses in support? Any in opposition? Any questions or comments from our committee members?
Mr. Chair.
Mr. Cedillo.
I was just wondering if the author and the people who support this, and I expect to vote on it, but there's other communities where access to the police is not that easy. So if I'm undocumented and I work in a house, cleaning somebody else's home, I shouldn't. My children to take care of their siblings. One disappears. I don't promptly run off to the police department, given that that call may result in my deportation. we're doing a lot of work trying to grapple with that in Los Angeles at DUI checkpoints, and we have a lot of leadership out of both our all of our law enforcement community, but it does create certain challenges for certain communities. Access is to law enforcement community, which is why we don't like to engage in immigration policies in Los Angeles. Access to the law enforcement community is difficult for some households. So I was just wondering if people thought about that, because that happens.
Ms. Mitchell?
Thank you very much, Mr. Cedillo, for that really insightful, relevant point. We worked very hard in the language to make sure that we're referring to circumstances in which the parent or their suspicion that the child is in harm's way, if you will. There's lots of conversation about the appropriate age level. We felt we've addressed that. Lots of conversation about the age at which children begin to run or run away from home. And so we've really worked very hard to be conscious of all of those kinds of circumstances. We'll continue to be mindful of that. But again, it's a circumstance in which the parent really feels that the child is missing and could be in harm's way. We've also been in conversation to talk about options to whom you report, and the fire department could be another alternative. And so we will certainly continue to have those conversations and take your point into consideration as we move the bill through the process. You have my word on that.
Okay, thank you. All right, is there a motion on this bill? So moved. Second? May we have a second? I'll second. Thank you. And I want to thank you for working with the committee on some of the concerns and the special circumstances that actually Mr. Cedillo has referred to. So thank you very much. I'm happy to recommend an aye vote on this. And it's been moved and seconded. And roll call, please.
Amiano?
Aye.
Amiano, aye. Knight? Knight not voting. Cedillo? Cedillo, aye. Hagman? Mitchell?
Aye.
Mitchell, aye. Skinner? Skinner, aye. Vacancy. Bill's out.
Thank you very much.
Thank you very much.
And Ms. Skinner, may I ask you to chair for me? Thank you.
Assemblymember Amiano, you're going to be presenting on item number 8, AB 1270. Please proceed.
Thank you very much, Madam Chair. Madam Chair and members, thank you for the opportunity to present AB 1270, which expands the media access to California prisons. AB 1270 would restore the media's ability to request face-to-face interviews with specific inmates and require CDCR to respond within 2 days. CDCR would have discretion over these interview requests, but any denials must be accompanied with a written explanation. This bill protects interviewed inmates from acts of retaliation by CDCR and also requires that crime victims are notified prior to any interview. Currently, the media is limited in interviewing a pool of inmates pre-selected by CDCR, which creates an inherent bias. Media can access specific inmates during regular visitation hours, but are not allowed to record such interviews, and telephone interviews are limited to 15 minutes. Inmates kept in secure housing units, the SHU, have no visitation or telephone privileges, and information about their solitary confinement punishments are largely unknown to the public, even though a disproportionate number of inmate suicides occur in the SHU. Greater media access would bring more transparency and public accountability to our closed prison systems. It would ensure that tax dollars put towards corrections and rehabilitation are used effectively and appropriately. I thank you for your consideration, and I urge an aye vote.
Do you have any witnesses in support?
Yes, Mr. Stathman, I believe, former assembly member.
Thank you, Madam Chair. Members, I actually had an escape plan. Do you all have one? Well, let me stop the jokes. You know, I'm Stan Statham. I'm the president, CEO of the California Broadcasters Association, and you probably don't realize what a tremendous media state you've got. I represent almost 1,000 radio and TV stations in California. This is the kind of bill that they love. And I know why so many San Franciscans have voted for Tom so long and send him here, fortunately, because he has really written this bill magnificently. Everybody is pretty much covered under this bill. You know, in 1996, regulations passed that prohibited the media with access. I represent the media. We are the media. You look to the media for support. We want transparency, as Tom quickly pointed out. What really pleases me about this bill that convicted criminals, crime victims, and their families and law enforcement should all be heavily supportive of this bill, because Tom has written it so defined that everybody gets their say before media interviews are allowed by newspapers, radio, or television. And even after that, the department itself, Department of Corrections, has the final say-so. So all this does is open up the doors to your government, and if I can be outrageous enough to say so, make this the best vote you ever cast and make it unanimous. Thank you very much.
Other witnesses in support?
Margaret Laffin for Legal Services for Prisoners with Children and for the Prison Hunger Strike Coalition in support of this bill.
Craig Brown for the California Correctional Peace Officers Association in support. This bill strikes the right balance between all the competing interests, and there are many in this issue. We think sunshine is a good thing for the prison system.
Thank you. Jim Lindberg, Friends Committee on Legislation of California, also in strong support for all of the reasons already expressed.
Ignacio Hernandez on behalf of the California Attorneys for Criminal Justice in support of the bill, and also on behalf of the California Media Workers Union in support of the bill.
Any other witnesses in support? Any witnesses in opposition? Hearing none, would you like to... we have a motion. Do we have a second? Thank you. We have a second. Assemblymember Amiano, would you like to close?
Yes, thank you very much. You all may recall a hearing that we did have about conditions in the SHU and how powerful it was, and how important it was for the relatives of the SHU inmates to come here. I think sometimes we undervalue that. You know, we usually don't have community members presenting their cases to us, and people had, under great hardship, bake sales and cupcake sales so they could afford the bus fare to come here. You know, and that kind of motivation and that kind of caring, I feel it's incumbent on us, of course, to respond. So this is one small step, as the gentleman said, to put sunshine not only on the conditions of the SHU, but how people got there, and the concerns and questions we all have about the efficacy and transparency of that process in placing people in the SHU. Sometimes we heard 20 years, 30 years. Unbelievable to me. So I thank you ahead of time for any support you will give towards alleviating the situations in the SHU, and urge an aye vote.
Thank you. And before we do the roll call, I'd like to make a comment in that. I appreciate that you included in the bill things like the notification to victims' families and other safeguards, or rather boundaries within it, because I very much support more media access within our prison system, but I also don't want to have a situation where, in effect, the media is purposefully or inadvertently, in effect, celebrating certain prisoners or giving them undue access to, to the public airwaves in a way that it doesn't really serve the public interest and would create a lot of pain for victims and their families. So I think that the bill, as was mentioned by some of the witnesses, does strike a good balance, and appreciate your care in drafting it. Is there any other comments any members want to make before we do roll call? All right, let's have a roll call.
Amiano?
Aye.
Amiano, aye. Knight? Aye. Knight, aye. Cedillo? Cedillo, aye. Hagman? Mitchell? Mitchell, I. Skinner?
Aye.
Skinner, I. Vacancy. That bill's out.
Thank you very much.
We have one bill on call. Yeah, let him with the call. No, we have one bill on call. We need to, item number.
Oh, yeah, that's right. Okay, we have one bill. Members, we have one bill on call, item number 4. Call the absentees. It's Assemblyman Ma, domestic violence battery.
Cedillo? Cedillo, aye. That bill's out.
All right, that bill is out.
Now we're done.
And now we are done. The meeting is adjourned. Thank you all.